They're safe right there. I think I could take them, but I don't want to fight them because there's 4 of them and there's only 1 of me. I don't think that's a fair fight. I'm waiting for my bags. There was an all-out fight over racism in the airport, and these girls tried to fight me. These girls tried to fight me. Please. About you or anything that you do.
Get down from this.
These guys.
Get down.
They're fighting me. They pulled me.
Get down.
Yeah, they pulled me and they're fighting me. And I'm staying away from them. I'm there because I feel safe there. I feel safe right there.
Okay, if somebody's trying to fight you, why aren't you outside? Why are you on top of this?
Because I'm waiting for my bags. And they came at me. They pulled my sweater. They tried to rip my sweater from me.
Is that your stuff over there?
Yes.
So you have bags coming?
Yeah.
Listen.
Yeah.
Relax, get your bag so you can get out of here.
Yeah.
If not, you're going to go to jail.
Oh, these ladies want to fight me.
Listen.
They said they're going to fight me outside. They said they're going to fight me outside. They said they're going to fight me.
Make sure you get out of here, son.
I think I could take them. No, listen. I think I could take them, but I don't want to fight them because there's 4 of them and there's only 1 of me. I don't think that's a fair fight.
Did you just listen to what the deputy
Yes,
said?
yes.
Okay, so that's what we're going to do.
I agree with you guys. It's not worth the fight.
Who's calling you? Somebody calling you?
Yeah, my friend. Hello? Hey. I'm waiting for my bags. There was an all-out fight over racism in the airport, and these girls tried to fight me. These girls tried to fight me. Yeah, I need you to come to the number 4 luggage.
Hello, I'm Broward County Mayor.
And on the plane, somebody got in a fight over my bags. I had 2 fights. I had 2 fights.
On October 31st, 2024, officers at Fort Lauderdale-Hollywood International Airport responded to a dispatch disturbance call at the baggage claim area. This footage presents a textbook collision between 2 legal doctrines: First Amendment speech protections and Florida's disorderly conduct statute.
Amy, come on.
Hey, go around like everybody else.
I know. I'm kind of like a bunny rabbit.
We know you will enjoy the stay. Once again, welcome to Broward County.
You got the car? Huh? Give me a car. You have your own car? Yeah.
I'm under arrest? Are you kidding me? How am I under arrest? Wait, does my boyfriend have to bail me out?
Yeah, we'll get to that later.
Are you serious? What am I being arrested for? Like, no, tell me what I'm being arrested for.
We're going to tell you. Give us
Like,
a second.
no, you don't have to deal. What have I done
Amy,
wrong?
listen to me.
What have I done
I'm
wrong?
going to explain everything.
What? Because I told him I'm not. This is reverse racism. I'm filing a lawsuit. I'm filing a lawsuit. I'm filing a lawsuit. You didn't do your job. I thought the 1 white man or the 2 white guys were going to defend me against the other ones. I know they're not racist, but like it doesn't matter. Like, how am I arrested on Halloween? How am I being arrested? How am I being arrested? I don't understand how I'm arrested. How am I arrested? I'm arrested? Is all my stuff, can you bring that to my boyfriend or my friend? Okay, I'm going to jail, I guess, for telling people that I'm not white privileged. I need my stuff.
What stuff?
Like my phone and all my stuff.
They're going to bring give me the phone.
On behalf of the entire
Take the charger out.
I'm being
Take the charger
arrested for
out.
telling people that I'm not white privileged?
what
the hell?
or visiting,
I'm white privileged, so I go to jail? Wait, am I going to jail because I'm white?
to the secret.
Wait, am I going to jail because I'm white? I'm confused. Am I too white for this planet? I'm white privileged, I'm sorry. I'm being arrested because I'm white privileged. Take a good look, I'm privileged and people attack me. Take a good look, guys. That's why I'm being arrested. I'm being arrested because I'm too white for this.
Under Florida statutes, Section 877.03, disorderly conduct requires conduct that corrupts public morals, outrages public decency, or disturbs the peace of those who witness it. Florida courts have consistently held that words alone are insufficient. The conduct itself must cross the legal threshold independent of speech. The Supreme Court in City of Houston v. Hill, 482 U.S. 451, established that speech directed at law enforcement, even profane or provocative speech, is protected under the First Amendment. An arrest premised solely on what a subject says to officers would be constitutionally infirm. The operative question is always, was the arrest grounded in conduct or in speech? Here, the conduct record is meaningful. The subject positioned herself on airport baggage infrastructure, sustained a verbal confrontation with multiple travelers, and refused repeated de-escalation offers. She also disclosed 2 prior altercations that day, one on the aircraft, one at baggage claim, effectively providing officers with a documented pattern of disruptive behavior. Under Graham v. Connor, 490 U.S. 386, reasonableness is judged from the perspective of a reasonable officer on the scene, not in hindsight. Officers arriving to an active multi-party disturbance were entitled to act on that totality. The subject's later performative statements explicitly inviting bystanders to observe her as a symbol of racial injustice introduced a conduct element distinct from protected speech. Sustained public spectacle directed at airport crowds in a confined, high-traffic space moves closer to the conduct threshold Florida courts require for a valid disorderly conduct charge. The subject also verbally threatened civil litigation, a Section 1983 claim under 42 U.S.C. Section 1983 would require proof that officers violated a clearly established constitutional right under color of state law. Given that the arrest was supported by conduct-based probable cause rather than speech content alone, such a claim would face significant evidentiary challenges at the threshold stage. The subject was charged with a second-degree misdemeanor carrying a maximum of 60 days, imprisonment, and a $500 fine under Florida statutes, Section 775.082. Case disposition remains unconfirmed through Broward County public records at the time of this analysis. All legal conclusions here are based exclusively on the footage and applicable Florida law.
I was like Britney Spears with Peter. Yeah, kind of told me what to do. Too much. Do not lose that hat. That's my favorite hat.
I got Julie.
It's my favorite hat. Do not lose that hat.
My
favorite hat.
Go ahead, get in there.
How long do I have to
Waiting
be
for
in jail
Julie to
for?
pat her down.
How long do I have?
Gotta
Wait, what is the charge? What's my charge? What's the charge?
Go ahead, take a sit.
What's the charge? What's the charge? What charge?
Responding officers receive a B, the initial de-escalation approach offering the subject a clear exit before moving to arrest reflects sound, tactical, and legal judgment. No force beyond handcuffing was used. Officers maintained composure throughout sustained verbal provocation and handled the subject's property concerns professionally post-arrest. The grade falls short of an A because officers did not clearly articulate the specific grounds for arrest at the moment of handcuffing, a procedural gap that increases civil liability exposure. The arrest timeline following the subject's inflammatory racial commentary also creates a pretext vulnerability, even where underlying conduct-based probable cause exists. The subject receives a C+. Her non-resistance during arrest and awareness of legal remedies are noted, but her decision-making throughout the encounter materially worsened her legal position. She declined multiple de-escalation opportunities, disclosed prior altercations voluntarily without invoking her Fifth Amendment right to remain silent, and transformed a private dispute into a sustained public performance. Each of those choices provided officers with additional factual and legal basis to support the disorderly conduct charge undermining any subsequent suppression argument. Her threatened lawsuit, while constitutionally permissible to announce, was strategically counterproductive at the scene, escalating rather than de-escalating a situation already tilting against her. Key takeaway: the line between protected speech and criminal conduct is a conduct line, not a content line. Courts do not ask whether the words were offensive, they ask whether the behavior disturbed public order. Travelers in airports, transit hubs, and other public conveyances carry the same constitutional rights as anyone else, but those environments impose higher baseline standards for public order. When law enforcement arrives, the smartest legal move is always the same: comply physically, stay silent verbally, and litigate later. Courtrooms offer far better remedies than confrontations. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.